place that are trying to do that. So, good morning. This is cause number 190533, National Indemnity versus the State of Montana. Are counsel ready to proceed?
I am, Your Honor.
Yes, Your Honor.
And I'm pretty sure Mr. Sullivan would be too. So it's
yes, I am.
Ms. Forshaw.
May it please the court. My name is Mary Beth Forshaw, and I represent National Indemnity Company, the appellant in this proceeding. I would like to reserve 10 minutes of my time. This case arises from a windfall judgment that requires National to pay more than $97 million under an insurance policy with a $3 million limit. The policy insured the state for the 2-year period of 1973 to 1975. Although the policy states explicitly that it only applies to bodily injury that occurs during its 2-year term, the judgment imposes on National the bulk of the state's liabilities for decades of asbestos-related injuries suffered by the Libby claimants. National sympathizes with the residents of Libby, but their claims are not before this court. This is a contract dispute, and National's policy does not cover the state's Libby-related liabilities, and certainly not to the tune of $97 million. The Libby claims present one occurrence under the policy, and the policy's $3 million occurrence limit is exhausted. Given its hurdles to recover under the policy, the state, not surprisingly, urges this court not to look at the contract language and to impose coverage by estoppel. The judgment should be reversed because the district court misinterpreted the policy and misapplied estoppel. At all relevant times, National has acted as a responsible insurer, consistent with Montana law, by offering to fully defend the state pursuant to a reservation of rights. Although the state refused to accept National's defense offer, National nevertheless continually offered to reimburse the state for its legal costs. The state refused this offer too, and only provided National with defense bills when ordered to do so by the district court. National promptly issued a $6 million check to reimburse the state for its defense costs, but the state refused to cash it. But even though the state wasn't interested in National's defense, National did not abandon the state. To the contrary, National supported the state by providing input on litigation strategy, by providing the services of an expert in asbestos defense and claim valuation, and National also participated in mediations and contributed $16.1 million toward a global settlement of claims. National commenced this litigation only months after that global settlement. For that reason alone, this lawsuit wasn't untimely, especially since the parties executed a tolling agreement and made multiple attempts to resolve their coverage disputes beforehand. Nothing about this action, the timing of this action, harmed the state. The state, in fact, recognized before litigation was filed that it made sense for the parties to put off litigation. On these unique facts, there's no basis to estop National or to require it to provide coverage the policy doesn't provide. This appeal should be resolved on the plain contract language and the judgment reversed. I'm going to first discuss certain of National's coverage defenses, which drive more than $30 million of the judgment and also apply to currently pending Libby claims. I'll then address the estoppel ruling relating to claims filed prior to the commencement of this litigation. Sorry, I never cough, but it's only because of the mask. The Libby claimants allege that they were harmed by the state's decision not to disclose the toxic asbestos conditions at the Libby mine based on a 1942 Attorney General opinion. As we briefed extensively, there are several reasons why this alleged harm doesn't fall within the coverage of National's policy. First, under the known loss rule, coverage is barred because the state knew of severe injuries and deaths from asbestos in Libby well before the policy incepted in 1973. The losses were thus not fortuitous and therefore aren't covered. Second, and relatedly, the policy covers bodily injury caused by an occurrence. There's no insurable occurrence here because there's no occurrence when an insured's intentional act causes expected harm. Paragraph 37 of Gore recognizes that the question of whether the risks were foreseeable at Libby had been answered as early as 1956. The dangers to the workers were already clear and present by that time. That's what the decision says. Paragraph 8 of Maryland Casualty likewise recognizes that the state knew of asbestos dangers in Libby in the 1950s and 1960s. The state concluded, in fact, in 1959 that, quote, inhalation of asbestos dust must be expected sooner or later to produce pulmonary fibrosis. Given the state's clear expectation of the harm for which it now seeks coverage, there's no insurable occurrence and the national policy is not obligated to respond.
Ms. Borshad, isn't there a distinction, though, between knowing of the harm, that being the asbestos-related diseases, and the knowledge of their liability in terms of the failure to warn?
Fortuity doesn't look at knowledge of liability. Fortuity looks at knowledge of loss. If it looked at, do I know if I'm going to be liable, you could have someone run out after an accident happened, buy a policy, submit a claim, and say, hey, I didn't know if this guy was going to sue me. I didn't know if I'd be liable. So I think fortuity goes to, do you know that a loss is going to happen? That's certainly what the occurrence test looks at.
But is,
did you expect a loss would happen?
Well, but then when you're talking about did you expect a loss would happen, is there a foreseeability that the state expected that they would be sued for failure to warn as opposed to just W.R. Grace being sued for the actual exposure?
To me, and under the policy and under fortuity principles, it doesn't matter if you expect to be sued. What matters is if you expect the harm. But even if the Libby claims could be construed as presenting an insurable occurrence, at most they present one occurrence, meaning that only one occurrence limit is available to pay the claims under the policy. National's prior $16.1 million payment on a non-waiver basis toward a Libby claim settlement exhausted the $3 million occurrence limit of the policy, and National doesn't owe the sum it was ordered to pay under the judgment. The limit of liability section of the policy states that the occurrence limit applies regardless of the number of persons who sustain bodily injury or the number of suits or claims brought. It further provides that all bodily injury arising out of continuous or repeated exposure to substantially the same general conditions shall be considered as arising out of one occurrence. Hegum construed similar policy language and adopted a cause test to determine the number of occurrences. That test calculates the number of occurrences by evaluating the cause of injuries for which coverage is sought. And the focal point is the allegations against the insured. The relevant question is therefore, in what way or ways is the state accused of causing injuries? The answer as to the state is that the Libby claimants allege that they were injured by the state's singular decision not to disclose its public health concerns based on that 1942 Attorney General opinion. The Libby claims thus present one occurrence. The district court erred when it found that each claimant's unique occasion of exposure leading to injury presents a separate occurrence. That ruling focused on the effects of the state's decision, that different individuals were ultimately exposed to asbestos at various points in time and to different degrees. But the relevant test is, what did the state do that caused the injuries to happen? As to that question, there's one singular cause of injury here: its decision not to disclose risk of harm. The district court also ignored the plain language of the single limit endorsement. It indicates specifically that the number of claims and injuries are not relevant, but that's really what the district court analyzed. It looked at the number of claimants, decided their injuries were different, and held every injured claimant as its own occurrence. Finally, the district court's errors are clear from the cases it cites, Prudential Lines and Metropolitan Life. They don't apply a cause test, the one that governs in Montana. They apply the unfortunate events test applicable in New York and the events test applicable in Connecticut. Montana's cause test requires analysis of how the policyholder is accused of causing injury. Whereas here, a policyholder is sued for causing harm through an overarching policy that gives rise to multiple injuries, such as an employment policy or a policing policy, or as here, a policy not to disclose. There is one occurrence as to the party that implemented the policy. Now, to the extent you find that the policy responds, National is only liable for injury suffered during the 2-year term of its policy. In at least 3 places, the policy provides that it only responds to bodily injury that occurs during the policy period. The policy limits territory clause, that's at NICO Act 103, states explicitly, quote, "This insurance only applies to bodily injury which occurs during the policy period." In addition, at NICO Act 104, the policy defines bodily injury, one of the types of losses it insures, as bodily injury which occurs during the policy period. That means every time you see the word bodily injury in the contract, it means bodily injury which occurs during the policy period. Likewise, the policy refers to bodily injury during the policy period in the definition of occurrence. And remember, that's what the policy responds to.
So, counsel, do you agree that the bodily injury is the exposure?
The bodily injury is the bodily injury that is suffered during the term of the policy.
Well, so...
And it could be exposure in residence
So
during the
let's
policy
say,
period.
well, exposure that manifests itself 10, 15 years later.
Correct.
Okay.
So it couldn't be more clear that whatever the injury that manifests during the policy, that is the injury that the policy is responsible for paying.
So, well, wait a minute. So you're not agreeing that it's the exposure that would manifest itself? For example, as you know, there are many people up in that area who have been diagnosed with the disease, but the actual injury or symptoms hasn't manifested itself at this point.
The injury needs to have manifested itself and happen and be provable to have occurred during the policy period.
Boy, that's
If it's a subclinical injury, the policy would respond. If there is actual injury during the policy period, the policy would respond to just that portion of the injury that occurs during the policy period. The state and the district court urge that the words that all sums that appear in the insuring agreement of the policy mean that the policy pays for all injury experienced by any claimant who might also have been injured during National's policy period. The district court did not read the all sums language in context. The policy requires National to pay all sums the insured shall be legally obligated to pay because of bodily injury. But remember, bodily injury is defined as bodily injury that occurs during the policy period. So the all sums that the policy pays is only for bodily injury that occurs during the policy period.
Counsel, how do you reconcile, though, in terms of if you have somebody who worked a number of years that included the policy period, so there was, it's not disputed that there was exposure during the policy period, but the nature of asbestos-related disease is that it's a cumulative trauma, it's a cumulative disease. So if the state is not able to apportion the injury, how do you apportion the liability to National Indemnity?
Sure. I would have you look at cases such as Crossman that are cited in the brief, and the various other cases we cite, the majority cases from around the country, that tell you what you do is you look at the injuries, the amount of liability of the injured person, and you prorate the amount that is due and owing by the number of years of injury. So let's say there were 10 years of injury, and let's say that National had 2 years of coverage. In that circumstance, National would be responsible for 1/5 of the injury, of the liability for the injuries. That's how Crossman and other cases do it. That's the majority rule around the country. And that's what's compelled by the way this policy is structured. The all sums language doesn't say that we have to pay each and every dollar attributable to an injured claimant. It says we just have to pay for that portion of injury during the policy period. And we know that because the all sums language goes on to say that the all sums for bodily injury that must be paid is that to which this insurance applies. And you remember a few minutes ago, I pointed out that the policy period territory clause says that this policy only applies to bodily injury which occurs, which happens during this policy period. So we know from the way this contract is structured, and frankly, the redundancy in it, referring to bodily injury that happens during the policy period, we know that that is the only obligation that this policy has. It pays that portion of the injury that occurs during its term.
It isn't as simple a calculation as you're making it out. I mean, you can also have, when you have exposures that are different, somebody's working in one area of the mine and then they move into an office. And so, I mean, what you're suggesting is you have a 10-year career. Let's say 2 of those years you're actually in it and you're mining, and then you move into the office for the last 8 years. But under your analysis, National Indemnity would only be responsible for 20% of the injury, even though the injury can't be apportioned. And But by essentially even looking at it factually, you have somebody who had higher rates of exposure during the policy period.
Courts around the country do the apportionment by taking a look at the claimant, assessing when they were exposed to asbestos, looking at medical documentation to figure out when their asbestos disease, the clinical changes, and other harm occurred within their body, how long it continued. And then they find, okay, did any of that happen during the policy period? When was the first date that it started? When was the last date where it ended because unfortunately of death or diagnosis? And then they do a proration by using a denominator and a numerator, as I indicated before. That is a common practice in the cases that we cited, and if you take a look, for example, at that Crossman case, that's how it's done. If the rule was not applied that way, there would be a moral hazard here. Not prorating indemnity to limit a policy's obligation to just the bodily injury during the policy period would reward a policyholder who went out and bought 1 year of coverage with the same amount of coverage that is due to a policyholder who responsibly went out and bought a policy year after year after year. The rule makes sense. The rule is also, frankly, mandated by the plain words of the contract. And that's why the vast majority of high courts that have considered this issue, 18 in total, 18 other states, have rejected the all sums approach followed by the district court and urged by the state. And I'd also note that the district court holding is largely based on an Illinois Intermediate Appellate Court decision, Caterpillar, that is unreported, and on its face it says it has no precedential value. Now, another reason why National has no coverage obligation is the pollution exclusion. It states this insurance does not apply to bodily injury arising out of the discharge, dispersal, release, or escape of contaminants or pollutants, including into the atmosphere.
Well, of course, the state's failure to notify or to disclose wasn't a pollution occurrence.
Sure, but the pollution exclusion precludes coverage for injuries arising out of dispersal, release of contaminants into the atmosphere. It does not have an active or involved polluter requirement. Those words are not in the pollution exclusion, but if you look at other exclusions in the policy, they specify whether a party has to be involved in the activity for the exclusion to apply. The absence of any sort of specification in the pollution exclusion means that an active polluter requirement should not be read into its terms. There's no dispute among the parties that asbestos is a contaminant, and there's no dispute among the parties that the Libby claimants allege that they were ultimately harmed by the release of asbestos. The injuries they suffered are excluded from the policy because the pollution exclusion refers to excluding injuries. And there is no requirement in its terms that the state or anybody else has to be involved for the exclusion to be triggered. Now, I'd like to turn to the allegation that National breached its duty to defend and should be stopped. National has always lived up to its obligation to defend the state. Plain and simple, the state refused to accept National's defense in what we believe is an obvious attempt to create through estoppel coverage that doesn't exist for all of the reasons I just articulated. As the district court found, An insurer should not be stopped when it offers to defend subject to a reservation, like National did here. Libby and Horseman recognize that it's appropriate for insurers to defend pursuant to reservation of rights, including reservations to recoup defense costs.
Ms. Borshaw?
Yes.
I'm over here.
Oh, sorry.
With the mask, it's hard to tell. I wanted to visit with you about this for a minute. Is there anywhere in this policy, I practically needed a magnifying glass to read it, but is there anywhere in this policy where it conditions the defense on recoupment?
No, there's not. But there's law that indicates law in Montana that indicates that a party is entitled to recoup defense if it didn't ultimately owe coverage. And for
But
that
Ms. Borshaw, isn't it statutory in Montana that every policy must contain the entire contract by statute in Montana?
yes.
So wouldn't it be an important condition of a contract to specifically define when an insurer may or may not seek to recoup? Wouldn't that be an important policy condition?
It's not a policy condition that has ever been required by the state of Montana, as I understand. And this court has repeatedly upheld insurers' rights to recoup defense costs when they reserve and provide a defense subject to a reservation. I'm not aware of any cases saying that that is something that is not allowed.
You mentioned both Libby and Hank, right?
I call it Horseman, yeah.
Horseman, Hank, either way, right? And certainly there was language in those cases that addressed defense costs, but do we agree that really recoupment was not a central issue in either case?
I don't know if I agree with that. I think both cases did involve reservations relating to recoupment. And the court, in at least one of the cases, and standing here I don't remember which one, did allow an insurer to recoup defense costs.
Right, well, in Libby, for instance, in that case, unlike in this case, the two parties both agreed to recoupment. Is that an important distinguishing feature?
That's right. And in those cases, the insured accepted the reservation and allowed the insurer to defend, and that didn't happen here. Nevertheless, I still think there was no violation of the duty to defend under Schwann and Keller in this case. My client didn't abandon the state. The state indicated they didn't want our defense. The state indicated they did not want the check that we wrote to them for defense costs or any reimbursement. They wanted to control their own defense of litigation, and we stood by their side and did not abandon them. We are, in the world of Schwann and Keller, in my view, a defending insurer. We didn't abandon them. We helped them out at every turn, whenever they would let us. We gave them advice, for example, on how to deal with the W.R. Grace bankruptcy. We assigned Brooke Green, an experienced asbestos claim evaluator, to help them evaluate how much they should pay the Libby claimants. We went to mediations and sat by their side as they negotiated with the Libby claimants, and we forwarded $16.1 million on a non-waiver basis to facilitate the first global settlement of Libby claims. So National was a defending insurer. National after 2006, National after 2005 stood by the state's side, helped defend the state, even though the state wouldn't let us take over. So I don't think we're...
So if we talk about controlling the defense, if an insured is under the understanding that they may have to pay back any defense costs and may have to pay any judgment down the road, how do you reconcile that with, I mean, isn't that part of wanting to control the defense if that's what your exposure is?
Sure. The insured here opted not to have us appoint new counsel, not to have us step in and take over controlling the defense. However, we continue to stand by their side. And under the law of Montana, including Schwann and Keller, we did not abandon the insured. Therefore, we can't be deemed to have breached our duty to defend. You may be getting to this issue. One of the reasons that National was stopped in part below was because the district court concluded that we untimely commenced a declaratory judgment action about coverage. We think that ruling is wrong. No Montana precedent required National to commence litigation earlier than it did. Staples recognizes that an insurer may offer a defense under a reservation and then later seek a declaratory judgment if and when coverage litigation may become necessary. And Dragon, Y, and Dubray declined to require defending insurers to file declaratory judgment actions when the underlying proceeding is pending.
Counsel, I'm not sure Tidy Man's is on the same wavelength as what you're saying.
How so?
I don't think in Tidy Man's, I think that was part of the issue, was the delay, or at least between the parties who filed the DEC action.
So here, the state suffered no harm from the timing of the DEC action. Under the unique facts presented, particularly on summary judgment, it's clear that National and the state agreed to preserve the status quo as to their differences before the declaratory judgment action was filed. They discussed deferring litigation. The state was aware of National's coverage defenses. They signed a memorandum of understanding by which the parties agreed to preserve their rights to litigate. They signed a tolling agreement. Counsel for the state called counsel for National and said, hey, let's mediate before we litigate. There was no harm to the state from the timing of the litigation. The state would have had us file a declaratory judgment action and go out and try to stay the Libby asbestos litigation. That doesn't make sense. Having us file a DJ action about whether or not we can reserve the right to recoup defense costs, all the while we're saying we'll defend you, doesn't make sense to delay, to file a DJ action and go to the asbestos court and say, hey, stop the asbestos litigation.
So I think we've been pretty clear in our law that we don't want to get into this, they did, they didn't, in terms of duty to defend. If there's a question, that DEC action is filed immediately. And I think that's what Tidy Man said.
But the DEC action, if we had filed it immediately, we would have litigated all these issues about the state's liability, like known loss, was there an occurrence, to the state's detriment. There are also cases like Dragon Y that say don't file a DJ if the underlying tort claims are pending. That was going on here. The underlying tort claims were pending, and there was no payment to a Libby asbestos claimant by the state until late 2011. We started our litigation only months later. Therefore, there's no prejudice. It would have been irrational and impractical for us to file earlier, go to the asbestos court and say, put the brakes on all of this litigation brought by people who are injured and dying, and stop all this litigation involving all these other defendants. Under the unique circumstances here, it made sense.
I dissented in Tidy Man, so that's okay.
Okay. I'm going to reserve, if you don't mind, the rest of my time. Thank you.
Counsel, before you sit down, Jim Rice here. Hi. Your briefing includes a section that indicates that on the issue of the duty to defend, there are outstanding factual issues that would preclude summary judgment. Now, you didn't take that position today. You sound pretty confident in, I guess, the facts as you argue them. Do you still take the position that there are remaining material facts in conflict, and if so, what would they be?
If you don't accept my arguments today, I think at a minimum, we need to go back and have litigation about the facts of the duty to defend, particularly with respect to the 2005 letter, the July 2005 letter. Our view is that letter offered a full defense. The state reads it differently. The district court read it differently. We think that that letter offered a full defense. In any event, even if it didn't, we cured any confusion by May of 2006 when a full defense was offered, and therefore the state has no prejudice, and therefore we satisfied our duty to defend. If you disagree with those assertions, I think at a minimum we need to go back and explore before a jury what was the meaning of the July 2005 letter.
Thank you.
Mr. Sullivan, are you out there?
I'm here, Your Honor.
Are you ready to proceed? Go ahead.
I'm ready. I'm starting. Good morning. I'm John Sullivan, and I'm honored to represent the state in this case. NIC claims it is unfair. The state contends that it is entirely fair to enforce this judgment in full because NIC breached its duty to defend, and there is all sums coverage for all claims of parties or claimants exposed before July 1, 1975. What is unfair is that NIC for now almost 20 years has been able to avoid its contract duties to defend and indemnify the state. Now, the state believes that this case can be decided on the basis of the duty to defend. I'm going to spend my time initially on the two duty to defend breaches that encompass all of the entirety of the judgment. And if I have time at the end, I'll go back to the failure to timely file the DEC action. The state, there are two breaches though, the failure to timely defend, and particularly the failure to defend your appeal. And then the failure to offer a proper defense, which the state rejected because it was defective. There is at no time has NIC ever defended the state in this case. It did not do so because when it made an offer to defend, those offers were improper and the state properly rejected them. There's no question about that. That's in black and white in the state's rejection letters. Now, the state tendered the claims to NIC in June 2002. NIC made no offer to defend until 3 years later in July 2005. And during that time, NIC failed to defend the appeal of the OR dismissal, and the state lost that appeal. That loss is forever. It applies to all claims, past, present, and future. And NIC admits that loss is the reason the state has had to pay multi-millions of dollars to settle thousands of claims. In other words, NIC admits the connection between the OR loss and the settlements that the state has been required to make and pay. Now, the duty to defend in Montana is triggered by notice of a potentially covered claim. That is all that is required, notice. And a potentially covered claim is one for which coverage can't be unambiguously denied. NIC admits the claims tendered are potentially covered claims. Their 30B6 witness admitted NIC could not unambiguously say there is no coverage because the claims allege bodily injury during the policy period and negligence. All of the claims allege negligence against the state. And in 2011, the 30B6 witness told the reinsurers that the claims as of that date, in all of those claims, the claimants alleged bodily injury daily throughout the policy period. So the tender gave notice to NIC of potentially covered claims. And when that happened, it triggered their duty to defend. In December of 2002, the state informed NIC of the OR appeal. NIC reacted by increasing a defense reserve it had already set and increasing it 8-fold upwards, but they didn't make any offer to defend. So the state defended the OR appeal on its own, and it lost that appeal. Now one could ask, would it have made a difference if they had? And the answer is, there's no way to show that because, as the court said long ago in Ellinghouse versus Safeco, the course cannot be rerun, cannot ever prove what might have happened if. But the important thing is that is not required. The state does not have to show that the result would have been different because since 1895 in Montana, the law has been when an insurer fails to defend and a loss is suffered by the insured, that loss is binding on the insurer. And Tiedemanns holds squarely that the insured's defense of itself does not forgive the breach. Now, the failure to defend the OR appeal in this case is actually game, set, match. This case can be decided solely on the basis of that failure to defend because NIC acknowledges that the OR appeal impacts all of and is the reason for the state's decisions to settle these claims. The Moody case holds that when there is a breach of the duty to defend, the insurer forfeits all policy defenses and all of its policy limits. The second breach of the duty to defend occurred in 2005 when NIC made its first offer to defend. And it said, we will pay defense costs pro rata, a partial payment of defense costs. The policy says that when an insurer is going to defend, it is NIC will pay all expenses of that defense, not part. And Montana law clearly holds that potentially covered claims must be defended in their entirety, not pro rata. So after 10 months of dispute with NIC said, okay, we will advance 100%, but we are going to reserve a right to recoup. Why is that defective? Because under recoupment law generally, and Montana law as well, an insurer cannot reserve a right to recoup as to a potentially covered claim. The Bus Court, which is the source of all recoupment law, held that in 1997, and this court in Schwann adopted that holding in Bus. When you look to that portion of the Bus decision about an attempt to reserve a right to recoup, it says clearly, explicitly, when an insurer tries to reserve a right to recoup as to a potentially covered claim, it is asserting a right it does not have. And the only way it can get that right is by a modification or supersession of the contract. Now, here is what NIC is not, this is no routine preservation of rights that NIC was asserting. What they were trying to do is to force the state to accept a contract modification. The state objected to that. NIC completely refused to budge, and they still do today. That is the state of the situation today. They've never changed that offer, and every time they make it, we refuse to accept it, which is why we said, we're not taking your money. We're not going to take your money except as part of the damages that are owed, because if we take your money, we accept the offer. Now that's why Libby is of no help to NIC. There are other distinctions of Libby, but here is the important one. In Libby, the insurer said, we will defend, but we reserve the right to recoup. And the insured accepted that offer. They said, yes, took the money, accepted the defense. And that in Libby, if you read the opinion, it says that's what made that offer enforceable. It was the acceptance of the defense under that term by Libby. The state here did not make the same mistake. We said, no, we do not accept your offer. It's defective, it's wrong, and we still don't accept it today. Now, the recoupment problem affects all claims to date, and those are all the claims in the judgment. And so those are the two breaches of the duty to defend that totally support the judgment in this case. This case can be decided solely on the basis of those two breaches of the duty to defend. In fact, it can be decided on the basis of the failure to defend or. Now, I want to turn at this point, I'll skip over the deck action issue because I know my time is limited, and I want to talk about coverage.
Counsel, before you switch gears, Jim
Yes.
Rice here.
Yes, Your Honor.
Just back on that duty to defend question before you leave, this is a unique duty to defend case that presents this kind of dual scenario of potential breaches of the duty. And I'll try to ask a compound question, so I only have to ask one question. But in your briefing, you do discuss, particularly at the last part of your opening brief, how the differences break out in terms of relief.
Right.
Whether the court adopts one breach versus another.
Right.
And I wonder if you could just summarize the liability behind that leads to that different conclusion in each scenario, particularly, why it matters that the breach occurs before or after the or appeal.
Well, the breach in this case occurred before the or appeal because the duty to defend existed at the time of the or appeal. It existed because the state's tender was of potentially covered claims. And so there was notice of a potentially covered claim, triggered the duty to defend. At that point, the job of the insurer is to mount and fund the defense immediately. They didn't. And when the or appeal was occurred, they didn't offer to defend that. They knew they had a duty to defend because they multiplied their defense reserve by 8, but they sat back and didn't offer a thing. Now,
I understand your argument on that.
right.
But of course, the district court rejected the argument, and that's part of your cross appeal.
Right.
And it said, well, the breach occurred after the or appeal. So what difference to the relief does it make if we would accept the district court's version of when the breach occurred?
Well, the court said it was after the or appeal because the court felt that a request had not been made to defend. but a request to defend is not required. Notice of a potentially covered claim triggers the duty to defend. Now, the or appeal would apply to every claim, past, present, and future, that will ever be filed in the Libby situation, because the or prejudice affects and infects all of those claims. And the NIC has acknowledged that that prejudice is directly connected to the decisions to settle claims. They say it, in fact, is the reason the claims were settled. So that is the failure to defend or is total liability for NIC for all Libby claims alleging the same or similar facts. Now, the breach of the duty to defend, if you take it solely for the failure to properly defend, and you ignore for a moment the or appeal, it might be possible, if that's the only breach, that breach could be cured as to future claims. When we receive a future claim and NIC makes a proper offer to defend. So the relief in that regard may be limited. It applies to everything to date because the offer that NIC has made has been defective from the first time they made an offer to defend. And finally, the district court is correct that the failure to timely file the DEC action would apply only to the $43 million judgment, because the DEC action was filed after that, and the claims that were settled after the DEC action was filed would not be within that.
Thank you.
Now, there is, in this case, all sums coverage for every claimant exposed before the end of the policy period on July 1, 1975. The reason that's fair is because, properly interpreted, that's what the policy says, and that's what it was intended to mean. You don't interpret policies by after-the-fact notions of fairness when a catastrophic loss happens. That is why people buy insurance. The problem with NIC's position, called the pro rata position, is that it conflates the trigger of coverage with the extent of coverage. The trigger of coverage is that some part of the bodily injury has to happen in the policy period. The extent of the coverage is if there is bodily injury sum in the policy period, all sums. And that's very easy to see from what the policy says and what it doesn't say. The policy begins with this language: NIC will pay all sums the state is legally obligated to pay. That is clear. And that language, all by itself, means that the entirety of any settlement or judgment is to be paid, all sums. Now, it then says that the settlement or judgment has to be, and this language is important, because of bodily injury to which this insurance applies, caused by an occurrence. The meaning of that statement is not readily apparent. And the state says, because of, and the references elsewhere in the policy to bodily injury in the policy period are the trigger of coverage. There's all sums coverage if some part of the bodily injury happens in the policy period. And the state in this regard is directly supported by this court's decision in which this court held that coverage is triggered if some, and it uses the word some, part of the injury is in the policy period. Now, in all cases of an exposure prior to July 1, 1975, there is, in this case, some bodily injury during the policy period. And because of that, the extent of the coverage is all sums. What what NIC read to you about and frankly, it's an amendment to the policy territory provision where they were expanding the territory from the United States to anywhere in the world. But she read a provision in there that said, that doesn't amend in any way the all sums provision. It says it only applies to bodily injury in the policy period. That's not what the policy says. Policy says all sums is paid of liability because of bodily injury to which the policy applies. And that means, and that's what that means, and that's what every other reference in the policy period bodily injury means. Some part of the bodily injury has to be in the policy period. Now, NIC says that what that because of language means is that all sums is limited to just the dollar amount of just the injury during the policy period. And that dollar amount is to be estimated, assigned, by dividing the policy period years by the years of injury, or the years of the state's self-insurance, which is apparently their argument on appeal. What NIC wants is limited, specific coverage, but that's not what they sold. They sold comprehensive general coverage. Now, there's a lot of reasons why that interpretation by NIC is wrong, but the rubber meets the road when you look at this court's decision in the Winter case. And it says this: limitations of coverage must be clear and unambiguous. And if they're not, the policy is interpreted to extend coverage. The limitation NIC wants is not clear for two reasons. The policy does not clearly say it applies only to the dollar value of the injury during the policy period. And second, there's no pro rata formula in this policy that clearly says a settlement is to be allocated by dividing policy period years by years of injury or years of self-insurance. Now, there's three more things that make it very clear the interpretation the state wants is correct. The first is the drafting history. And for that, we have drafting history explained in an expert report endorsed by another Berkshire subsidiary, just like NIC. And we have the United Policyholders brief as well. And they say basically that what was intended here is an all sums policy, and that the drafters thought about adding a pro rata provision and decided for competitive marketing reasons not to do so. Second, and this is very important, occurrence causes. We've got two sets of occurrence causes here: 21 events of failures to warn and thousands of individuals from the occurrence exposure cause who are exposed to asbestos or grapes. Those don't have to happen during the policy period. They can happen before the policy period, and there's no limitation on how far back that goes. The only question is, does some bodily injury from those occurrence causes happen during the policy period? And NIC's 30B6 agreed that's the correct interpretation, that it's not limited to the policy period. And so we know that there is a lot more coverage here than just 2 years. And third, there's nothing in this policy that says the loss can be equitably offloaded to the state. What the policy says is that NIC can offload liability if the state has other collectible insurance. We don't. Hinsky, an old case.
So, pardon me, just repeat what you said. Your words didn't quite come through there.
The policy has an other insurer provision, and it says that NIC gets to offload liability if the state has other collectible insurance. Don't have collectible insurance. Pinsky, an older case, holds squarely that it is against Montana public policy to offload liability if the state it is against public policy to equitably subrogate against the insured. The state's finally self-insurance is not other insurance because there's no transfer of risk. Now, if there's one more T to cross, was the trigger satisfied? Yes, 4 reasons. Swank holds coverage triggering bodily injury can be proven retroactively, and it doesn't need to be diagnosable or manifest during the policy period. We know today asbestos stays in the body indefinitely, and in susceptible persons, if it is there, it causes latent, continuous injury from the time of first exposure forward. All claimants are susceptible because they all have an asbestos injury diagnosis. Their records are in the record. And so the state asked its medical expert to review the records for claimants exposed before 7/1/75 and asked the question, did they have bodily injury during the policy period? And she unequivocally said, yes, they did. And there's no opposing medical expert. A quick note or two about the policy limit. The policy limit is $3 million per occurrence. That's in subsection A of the endorsement 1. There is a $3 million aggregate, but the 30B6 admitted it doesn't apply to the CGL coverage here. And in subsection C, there's a batch clause that says that batches into one occurrence all exposure injury arising out of substantially the same general conditions. Now, they don't, because exactly what the district court said, the exposure history of each claimant here is unique. It is from substantially different specific conditions. It is from Grace operations, but those operations were many and varied. They covered a large geographic area from the mine all the way into the town. They occurred over a long period of time, and these claimants were exposed at different times in multitudes of different ways and places, and to different and constantly changing amounts of asbestos.
So how do you address the MIC's argument that it's the state's conduct of failing to warn is what really is at issue, not this exposure to a history of unique occurrences with asbestos?
Well, what NIC is trying to say is that there's just one occurrence because the state is being sued for a policy of non-disclosure. That's not why the state is being sued. The allegations in these cases don't say policy of non-disclosure. They say you failed to warn 21 individual times. Now, the number of occurrences could be judged by either, we've got both types of occurrence causes in this case, events, 21 failures to warn, and exposures. And it could be either the district court chose one per exposure. We do not dispute that on appeal, and we leave it to this court to decide which of those causes to select. But if you select the failure to warn causes, it's not one. And the 30B6 witness for NIC admitted that, said yes, the allegations of these complaints are many separate occurrences, and each failure to warn, each of the 21 inspection reports is a separate occurrence. Briefly, I want to discuss known loss, and quickly. There's no known loss because known loss in a liability policy requires known liability. And the state did not know it was liable because it had sovereign immunity. until the day these policies were issued. Knowing and intentional requires highly certain knowledge of two things: injury, and that your actions are, your failures to warn are a direct cause of that injury. The state had neither. What the state knew was that there was a risk of harm to the claimants, and it believed that that risk of harm could be mitigated and alleviated by respirators. And at the state's recommendation in 1957, Grace began using respirators. The state's entire effort here was not to harm workers. The state had no intent to harm workers. The state wanted to protect workers. Now, did the state have any knowledge that its failure to warn was injuring the claimants because they didn't otherwise know? No. The state heard from the workers' union in 1964. And the workers' union in 1964 wrote to the state and let the state know, yes, the union knows the situation, and thank you, state, for taking the actions you have, because Grace has made many improvements. More are needed. And so the state continued its inspections. The important thing is that knowledge of a risk of harm is not knowledge of certain injury. Risk is that. And in this case, all of the claimants who are in this case had nothing but latent injury during the policy period. In fact, their injuries were not discovered and they were not manifest, they were not diagnosed until at the earliest, the late 1990s. They didn't know about them, the state didn't know about them. Pollution exclusion doesn't apply because it only applies to polluters. Here, the state is not the polluter. And so, Your Honor, I believe my time is either close or up.
You're up.
What we ask here is that this court enforce the duty to defend and the indemnity promises NIC made to the state. And Justice Rice is correct concerning the nature of the relief. It's somewhat complicated depending on what conclusions you reach and how you get there. And it's very detailed explanation of it on pages 69 to 71 of the state's brief. Thank you.
Rebuttal, yes, please.
Thank you for letting me do this from Seattle. I appreciate that. At our age, the risk of COVID is a problem. So thanks.
It's a beautiful.
I should turn my video off again, shouldn't I, here?
That's what the expert says.
Okay. And I should turn, well, I'll leave the audio on.
I'd like to address 3 points in reply. The first is that the cross-appeal relief that the state is seeking is extraordinary. They are basically seeking to stop my client from asserting any coverage defense for all time in connection with thousands and thousands of claims because when they sent 18 claims to my client after they had handled them on their own for several years, we called them, we said, hey, what's going on? And they said, don't worry about it. Don't worry about it. A motion to dismiss is pending. You don't need to do anything. Take a look, if you will, at NICO Act 224. This is an affidavit of Mr. Grangenet, who is the NICO employee, who contacted the state. As soon as he got these letters relating to 18 claims, he got some complaints, but not all. Then he got a follow-up letter and a few more, but not all. He called Mr. Cockrell. Mr. Cockrell told him not to worry about it. Motion to dismiss was pending. To keep him posted. Mr. Cockrell didn't keep him posted. Mr. Grangenet actually found out about the decision on the motion to dismiss on his own 3 months after it was entered. He called Mr. Cockrell Mr. Cockrell told him that the state had filed a notice of appeal and briefing was ongoing, and nobody had bothered to even tell National Indemnity about it. Nobody asked National Indemnity to get involved. Mr. Cockrell said, in words or substance, we'll sort things out once this court decides.
So counsel, you're not disputing the impact of the or appeal on the claimant's recoveries. You're disputing that you did, the duty to defend hadn't been.
Hadn't been tendered, and as Schwann recognizes, it would make little sense to provide other counsel when you're told counsel is not needed. So we didn't breach the duty to defend because no defense was asked of us, and even if you could construe a defense being asked of us between 2002 and 2005, under Schwann, we didn't breach it. But yes, you folks obviously decided the or appeal, or your predecessors, most cases, decided the or appeal, and that allowed the cases to go forward. It had impact on the litigation overall, but we were only tendered at most 18 claims during the period upon which they want to base this estoppel for all time. That is an extraordinary, unprecedented ask to void an insurance company's ability to assert its coverage defenses with respect to claims sent to it 10, 15 years later, where they timely issue a reservation of rights and bring a declaratory judgment action. Estoppel has to be applied on a claim-by-claim basis. It cannot be that the discussions between Mr. Cockrell and Mr. Grangenet somehow constitute a breach of the duty to defend. So that's my first point. My second point is that we are not asking you to apply equitable relief in connection with interpreting the policy and the fact that it says it only applies to bodily injury during the policy period. We're asking you to apply the plain words of the contract, which define what our policy responds to, what our policy owes. Finally, I just want to point out that the state has, in fact, done a bit of an about-face here. They advocated strenuously below that there were 21 occurrences presented by the Libby claims, and Mr. Sullivan referenced that in his argument. And they, like National, understood that it was the focal point in determining the number of occurrences is what was the state accused of doing. They just had a different interpretation. Their interpretation was the state was accused of harming the plaintiffs, the claimants, because they made 21 decisions not to disclose. We step back and look at why they made those 21 decisions. Those 21 decisions had a common cause, and that common cause was adhering to that 1942 Attorney General opinion. So the state, didn't about face on this appeal, suggesting that the district court's effects test applied to determine the number of occurrences was correct. They, like us, understand you need to look at why is the state being held liable.
Counsel, at any time, though, the state could have decided to reject the AG's opinion over the course of the years and do an about face and disclose, correct?
Sure, but it didn't. It made one continuous decision to stand firm and adhere to the Attorney General opinion. And so therefore, it was one continuous act that led to the failures to warn that all of the Libby claimants allege. The final thing I'd ask is that you heard a lot of statements about my client admitted this, my client admitted that. I'd ask you to look at the citations, because the citations do not support the notion that my client admitted 99.9% of what you heard. In fact, if you take a look at the reinsurance correspondence, for example, National told its reinsurers again and again and again that it had coverage defenses, that it had reserved rights. There were no admissions of coverage. They laid out the scenario and the story, and words should not be cherry-picked from documents. The documents should be read in full. It looks like my time is up. I thank you very much for giving this case attention, especially in these troubling times, and allowing us to come and argue. This is a very important matter to my client, and we appreciate the care that you've taken hearing from us and that you'll take in deciding the issues. Thank you. It's been a pleasure to be in Montana.
Well, thanks for coming to Montana, Ms. Forshaw. We appreciate the fact that you did. So this concludes the argument on national indemnity versus the state of Montana. The court will now take this matter under advisement, and we will issue an opinion in due course. Thank you to all counsel.